Good evening. Happy Tuesday. There were a couple of community page posts that I did today about goings on in the DeCastro versus Abrams et al. Defamation lawsuit. And no one seemed to really know what was going on much, so let me help everybody out. Earlier today, Kate's attorney, Benjamin Wish, filed this. It's a motion. It is a motion. It's an ex parte motion, essentially, that the court schedule an emergency status conference today. See, this was filed on today. It's an emergency motion for a status conference, and this is the emergency motion for a status conference. So it says defendant Kate Peter, Ms. Peter, hereby requests on an emergency basis that this court schedule a status conference on October 18th, 2022, or as soon as thereafter practicable, in order to address the threatening and harassing behavior of plaintiff Jose Maria de Castro, Mr. de Castro, towards Ms. Peter and undersigned counsel. Mr. de Castro has sent Ms. Peter and undersigned counsel menacing emails and voicemails and publicized them on YouTube, and repeatedly made clear to Ms. Peter that the goal of this litigation to try to intimidate and harass her. I think he missed an is, but that's fine. Undersigned counsel further understands that Mr. de Castro has threatened others, including her, has threatened others, including by saying he will dox, identify the identity, address, and other personal information of a person on the internet, and send his supporters after them unless those third parties provide affidavits in support of his claims. As Mr. de Castro put in response to counsel's request that Mr. de Castro please communicate with counsel rather than directing anger toward Miss Peter, Mr. de Castro wrote, among other things, Kate, I'm never going to stop until you're done. I will never, ever, ever, ever stop. And it's not just me. A true and correct copy of this chain of email correspondence is attached here to as Exhibit A, together with other emails from Mr. de Castro. The very day that undersigned counsel filed his notice of appearance, Mr. de Castro left undersigned counsel a voicemail, a transcript of which is attached hereto as Exhibit B. And then there's a little number one. A recording of this voicemail was posted on YouTube. See blah. Mr. de Castro concluded his email by saying, I think he meant voicemail, but that's fine. You're not my daddy. You're not my daddy. He said it so weird. You're not my daddy. I have no obligation to you. None. You. I don't owe you a goddamn thing. You're a blood-sucking law lawyer who doesn't give a shit about justice. You're doing court law cases. You don't give a shit about justice or the rule of law or the Constitution or America. There is no question that Mr. de Castro is using this litigation to drain Ms. Peter financially. As Mr. de Castro put it himself, I don't care if I win. I care that you have to hire a lawyer. I care that I extend the process for as long as I can to drain you. Now for the last time, you stupid retarded fuck. I'm not interested in any relationship with you, and I've continually told you this. I don't care that you're a loser and you have nothing going on with your life. You have no motivation. I don't care. Facebook message from Mr. de Castro to Ms. Peter, a true and correct copy of which is attached here as Exhibit C. Wherefore, Ms. Peter respectfully requests that this court set an emergency status to ensure that Mr. de Castro ceases harassment of Ms. Peter, her counsel, and others. Indeed, default of Mr. de Castro's lawsuit is warranted and necessary where he is seeking to leverage this process to attack, threaten, and drain Ms. Peter of her financial resources. Respectfully submitted, Kate Peter by her attorney, Benjamin J. Wish. And then the certificate of service, he served it via email and has further mailed him a copy. Served via email. Now, so what is he asking for? He's asking for default of Mr. de Castro's lawsuit. I believe that what he's referring to here is a terminating sanction, i.e. that de Castro's behavior is so egregious, so beyond the bounds of what the court should be used for. Because remember, the purpose of the court is ostensibly for people to get justice. That's the purpose. Now, Whether or not you can get justice at court is a completely different ball of wax, but that's the purpose. It's not there to be used to rake people over the coals for attorney's fees and to try to break them just from the cost of litigation. All right, so terminating sanctions, and in the alternative, to basically get an injunction against DeCastro harassing Kate and or her counsel. So the attached exhibits, this is Exhibit A, and these are emails from ya boy Chili. Oh no, no, you're not on the record. We checked the court docket, and you need to understand by learning, you can shove your cease and desist up your ass. Kate, I'm never going to stop until you're done. I will never, ever, ever, ever stop, and it's not just me. And he's responding to this very polite email, Mr. DeCastro. I'd ask that you please do me the professional courtesy of dealing with this matter on the merits rather than with invective and insulting emails and voicemails. While I understand you have significant anger toward my client, I would respectfully request that you communicate solely with me and refrain from ad hominem attacks. And that's from Benjamin Wish. And then there's this email. Fuck you, loser. I get about 100 of those per day, every day. This will not be amicable. He's responding to Benjamin Wish, saying, Mr. DeCastro, thank you for... I guess we'll start from the bottom, where he starts. Mr. DeCastro, please copy my colleague Rebecca O'Brien, copied here on all communications. I'm not responding to the substance of your... Oh, Jesus Christ. All right, let's find the start of this stupid email chain. All right, here we go. On October 12th, Mr. DeCastro, you mentioned in a prior email that you intended to file an amended complaint. When do you intend to amend? I'm just trying to evaluate whether we should put together our answer now or wait for your amended complaint. And Chili responded, you can go ahead and respond to my original complaint. There's a process here and we're going to follow it. So I'm just stopping there. This is my interjection here. Courts aren't really big on making people do stuff for the sake of doing stuff. They're not. They don't exist just to make people waste their time. Now, there's a lot of stuff that goes on that really feels like it's just wasting time, but the court would rather that Chili just go ahead and file his amended complaint and get it done with. Obviously, Chili doesn't want to do that because he has no idea what he's doing, and so he wants to see the response and hopefully learn from it to figure out how he needs to amend his complaint. Now, Chili's ability to learn is obviously subpar, so but I'm just saying that's probably what he's hoping to do. You might want to research your own case. It's going to be used in our court case. Speaking of things that are going to be used in our court case, not sure if you know this or not, but your client made another video about me last night, an hour plus long, just laughing and painting me in a negative light, lying, crazy, just sitting there lying, and the lies can be proven. I'm glad you grew up principled and that you're doing the right thing. Lol, I'm not giving you the amended complaint until you respond to the original complaint. Wait till I send over discovery. Wow, it's a book of clear IIED, that's intentional infliction of emotional distress, slander, and libel. Have a nice day. And then Wish responded, Mr. Castro, please copy Rebecca Bryan. Not responding to the substance of your email below. We'll respond to your original complaint. Just wanted to see if we could move forward more efficiently by addressing your forthcoming amended complaint. And then Chili responded to that. Not a chance in hell. We do every single step. I'm being harassed by 100 angles. Being harassed by 100 angles. Does he mean angels? Being harassed by 100 angles. Like Anglo-Saxon? Like the Angles and the Jutes? I don't know what he means there. I'm being harassed by 100 angles. Anyway, I'll not stop until I end this nonsense. Kate used to dress up in a pregnancy outfit and go and ask for coat hangers at clinics. Not kidding. She's done this harassing to at least 6 people. I have sworn statements from them. She's being sued by another guy I know. I'll send you the evidence and discovery. She's a bad person. Best of luck. I'll await your response to my complaint. Glad you're making money, bud. Glad that you only care about money. Think about it. Why else would you represent a shithead like Kate? Money, 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 money. Sad, pathetic. Now it's kind of interesting. Again, I'm just interjecting here. I'm not reading his email at this point. A couple things. It's weird because I believe around this time, October 12th, I believe that him and his little buddy discussing laws were accusing Benjamin Wish of representing Kate pro bono because Benjamin Wish does pro bono cases. At the same time, Benjamin Wish only cares about money. Huh? Isn't that kind of weird? Another thing is that all the things he's talking about here, the Kate dressing up in a pregnancy outfit and asking for coat hangers, and harassing 6 other people, and being sued by another guy that Chili knows, is not evidence. That is not evidence. Her being a bad person is not evidence. The only thing that matters is the intention. Was it intentional infliction? Did he sue for intentional infliction? But I know it's the defamation. I mean, you don't lose at court because you're a bad person. You lose at court because the other side proved the elements of their case against you. So Wish responded, Mr. Castro, thank you for clarifying that you will await our response to your complaint rather than amending now. Please refrain from the invective and name calling. It's unhelpful. To which Chili responds in a very grown-up fashion, fuck you loser, in quotes. Who he's quoting, who knows. I get about 100 of those per day, every day. This will not be amicable. All right, so that was that email chain. And then was there another one? Yes. Let's see where this one starts. All right. So this one starts off with, Benjamin, I apologize for the 3:30 in the morning email. I just realized. Hard to sleep when you're snorting rails, huh? After talking it over with my people, I'm afraid I can't discuss the motion with you because I haven't received a letter of appearance from you. I have to receive your letter from you in the mail. Federal Rules of Procedure 5B. Now, 5B is service how made. Service in general. By handing it to the person, leaving it, yada yada, mailing it, leaving it, sending it to a registered user by filing it with the court's electronic filing system or sending it by other electronic means that the person consented to in writing. Now, I don't know if anybody remembers this. This is the opposition to Kate Peters' and or Abrams' motion for extension of time. Now, he filed 2 of these. I don't know if you remember. One of these was this one. This is the one that got there first. And this is the one that he actually signed, dated October 3rd of 2022. This one got there first. But I guess he got worried and he filed this one, and he did it electronically. See, not sure why it hasn't been filed yet. But anyway, ya boy Chili is in the electronic filing system. Ya boy Chili, that /s. This was electronically filed, and he's registered with the Chili at situationcreator.com. Just in case anybody's wondering. Anyway, so he doesn't have to receive the letter because the electronic filing system he's registered to. I'm only including you on emails as a courtesy. Kate Peter runs a troll mafia. They enjoy reading out loud personal court documents, and if they can infiltrate and disrupt, they will. These are public record. They can't really infiltrate a phone call if I was to call your office, though. I'd more than willing. I'm more than willing to jump on a call with you to work this out. Granted, I will have counsel on the phone and will also be recording the phone call. I feel like it's always important to have counsel. I don't know that he actually has an attorney. I think he's just calling someone counsel. I have a Sixth Amendment right to be assisted by counsel, not led by counsel. There's a big difference between those two things. It's important we use our rights in a way that they were originally intended. Yeah, the Supreme Court has interpreted your right to counsel in the Sixth Amendment, and the Sixth Amendment right to counsel is for the assistance of a attorney, a licensed attorney. States can control who can be counsel by requiring license. And also the Sixth Amendment, as your boy discussing law has so eloquently pointed out, applies only to criminal cases. Your Sixth Amendment right to counsel only applies to criminal cases. Your right to counsel in civil matters is derived from the Due Process Clause and what's the other one? Your First Amendment right to freedom of association. But I'm sorry, I shouldn't be lecturing a constitutional law scholar about that. To continue, I feel bad we got off on the wrong foot because when you're being stalked everywhere you go, it really gets you in an emotional place sometimes. I'm really sorry. I'll admit that I've been emotionally volatile because of all the vicarious positions. All the vicarious positions? Oh, Jesus. It's a big word. Sounds kind of like it means the right thing, so I'll use it. Because of all the vicarious positions that your client, or your so-called client, has put me in. I think he means precarious. I don't think he means vicarious. Anyway, hopefully we can work some things out on the phone and have a little bit better understanding. Although, I really can't get on the phone with you until I get served notice of your appearance, Rule 5B. Trolls are really bad. Really disrupt communications and make things difficult for everybody involved. It's terrible and it has to stop. I have to follow every little rule or I can really put myself in a dangerous position. Yeah, you're in a dangerous position right now, dude. Your case could be terminated. So, I mean, I doubt it will. Just cat out of the bag. I doubt it will. That would be a pretty big step for the court to take, but they could. So, one of Kate's trolls stalked me down last night, and I had to physically defend myself. It was awful. And then here's a video. Because time is important, you could start this at 1 hour and 23 minutes exactly. Well, so, yeah, but see, it's not about... No, he doesn't have to watch that. The stalker starts off by saying Kate always wins. He comes from the hate channel that your client runs. Kate is being sued. Really? Really? Kate's being sued? I mean, I think the attorney that she retained to represent her in the lawsuit understands that she's being sued. Jesus. Hopefully by Wednesday, I will have received your notice of appearance and we can officially talk. I do appreciate your time. I hope we can clear this up and be better friends. I'm a very loving, warm person. I'm sure you are too. Now here's a fun thought. There is an attorney-client privilege. There is anything that a client talks to his or her attorney about is privileged, i.e., you can't discover it. Well, you most likely, it's next to impossible to discover things that are protected by the attorney-client privilege. Now, if this counsel that he's claiming he has is not an attorney, there is no attorney-client privilege. And so if ever opposing counsel figures out who this fella is, they could depose him and they could ask him all sorts of fun questions, subpoena him for deposition, and ask everything that he's ever talked about the case to Chili about, and hear everything that Chili has ever said about the case. I wouldn't ever try this particular tact that Chili's trying, but Chili does a lot of stupid things. So on October 17th, Benjamin Wish said, Mr. DeCastro, I have mailed my notice of appearance to you. I also emailed my notice of appearance to you at this email address. It's also available on Pacer. I take your email below to mean you're not willing to speak to me until you're in receipt of my notice of appearance by mail. Let me know if I have that wrong, though. I also note that Massachusetts is a two-party consent state, and I do not consent to your recording me. Please do let me know if you'd like to speak about the basis for your contemplated motion. California is also a two-party state. So if Chili records people, if he always records and he doesn't tell the person he's recording, then he is violating California state law. I mean, there's penal codes against that. And then we have some bullshit here. This one is Benjamin. I hope this email finds you well. If you are Benjamin, if you are actually representing Kate, this is on October 17th. I just don't know. I have not received anything in the mail from you. I can't trust email. Before you and I can confirm, but you can trust Pacer, right? I have to receive a certified letter in the mail according to Rule 5B. We've already shown that to be wrong. I'm available here at home here in Santa Monica, which is a very scary thing to let your client know. People have come to my home. I have a video. They pulled up to me and said, "Kate always wins." It was quite scary. You little bitch. Fucking sack up, you little bitch. Someone says Kate always wins, and the first thing you do is what? Get your panties in a bunch? Oh no, Kate always wins. Oh no. You little fairy. We have filed a subpoena with the Florida DMV to get the license plate registered owner. They have filed for. They've requested. He's requested. I don't know why he says we. I will be going after that person legally for stalking. Oh, congratulations. Thanks for wasting our time with it. Maybe ask this person, Kate, that you've decided to represent, to not divulge my location at this moment, so that I can have some sense of normalcy in my life and be able to receive your meal. Your mail? Or your meal. Maybe he's hungry. I don't know. I'm not going to be home if I can't be sure that my safety isn't in jeopardy. Please confirm with your client to ensure she's not going to reveal my location so that I can chill at home and wait for the mail to be sure that you are you and you are following federal rules procedure. Federal Rules Procedure 5B. Boy, he learned about 5B and he just can't let it go. But yeah, I would need the actual letter in the mail. It doesn't matter what you say on email. Kate has a troll mafia. This is what they do. I don't have electronical filing, so I'm not privy to what is posted there. I don't know. Sorry, man. Liar! Liar! Kate has destroyed my trust in my fellow man. I wish I could trust you. I can't. That's why we fall back to Federal Rules of Procedure 5B. After I get this service, Benjamin, I hope we can talk on the phone and have a decent conversation. All my calls are recorded. Every single one. So maybe we won't be able to speak. I don't know. You'll have to decide that. I can promise you, though, that my journalistic endeavors do not include this. I could stipulate with you that I won't broadcast our discussion. I'm not interested in using this case as social media fodder. That's what your client does. That's exactly what she does. So while my call might be recorded, I'd be willing even to sign in an agreement that I wouldn't broadcast the conversation. I'm looking to work with you in good faith to have Kate remove every single video about me, make a full apology, and then decide with the financial settlement we'll be moving forward for the next several years. As soon as I know you're the actual attorney on the record, and then you file a response, then I'll send you my amended complaint. And the discovery that goes with my amended complaint, it's thick. She has done a lot of stalking and hostinf? And hostinf? Hosting? Posting? Ghosting? I don't know. She's done a lot of stalking and hostiff stalking and lolling about stalking me. I think maybe posting stalking and lolling about stalking with me. She calls me an lol cow. Well, you are a lol cow, Chili. She laughs that me being stalked is a major problem for me. You make it a problem about you, dude. Here's the bonus for you guys. Last night, someone identified her fake user handle in Discord as being Kate from the Troll Mafia channel on YouTube. We really needed that to happen, and it finally did. Super grateful. I really hope that this someone of normalcy. I really hope this someone of normalcy enters this conversation very soon. Your client is a deranged lunatic. She is already starting to defame, harass, and attempt to destroy another person's life. She's already picked her target. She's already talked about it on her Discord account. If she put the same focus into her children, she wouldn't have lost two of her sons. Respectfully, Jose M. De Castro, aka Lolcow. Remember that my stipulations are to mediation or arbitration or anything of the kind. Do you even understand the difference between mediation and arbitration, Chili? You stupid idiot. Do you understand? There's a world of difference between mediation and arbitration. Mediation is when you go in to a mediator and the mediator tries to come up with a negotiated agreement between the two of you. Arbitration is basically like going to court. You have an arbitrator who's not a judge, but he does the same thing. He's the judge and jury for your arbitration. You go in there, there's a rules of evidence, there's probably arbitration rules as well, but you present your case, there's discovery, there's all that sort of stuff, and then the arbitrator makes a decision. The arbitrator renders a judgment. And the arbitration might be binding or not binding. There's differences about those. If it's binding, then that's the order, and you could actually go to court and get a petition to have the arbitration award confirmed. If it's not binding, it might become binding eventually if you don't move to vacate the arbitration award or whatever. I mean, depending on your state, but it's just like going to court. It's just like going to court. It's just like having a judge render a decision on your case and render judgment on your case. So I don't know, like, he hears words, dude, and like he doesn't understand what the hell he's saying. Anyway, number one, Kate has to remove every single video about me, any likeness, my voice, anything Haas to be removed. Kate has to say she's sorry and she regrets what she's done. Number three, an initial payment upfront, then a financial settlement moving forward in perpetuity, including a percentage of her YouTube channel, and all earnings is going to have to be established. Otherwise, we're going to trial. Still laughing, Katie? I think it's fucking hilarious myself, but that's just me. And all right, that's the end of the emails. And then there's Exhibit B. Is a transcript of the voicemail. We've all heard it. I'm not going to read it. It's creepy. It's weird. Hi, hey Benjamin, my name is Jose De Castro. I'm a really nice person. Yeah, it really sounds like a bro. And then there's Exhibit C, and Exhibit C I've never seen before, so we're going to go through it. This is apparently a Facebook post to Masshole Report. It's been brought to my attention that you've reported that I have a criminal record. I believe you do. I believe a judge in one of the civil harassment restraining order hearings, what do they call those, HPOs, identified that you have a criminal record. So yeah, you have 24 hours to retract your statement or face a lawsuit for defamation. If you do not retract your statement publicly, I will file a lawsuit against you for defamation via slander. Your continued policy and practice standard of operation proves a pattern of harassment, and at this point I'm willing to take legal action. I have documented that I've asked you to leave me alone. I've documented that I forcefully with vulgarity, that's a legal standard. If you tell someone to fuck off, that has more weight in court, according to Chile, apparently, than if you ask them politely to leave you alone. So anyway, I've documented that I forcefully with vulgarity told you to leave me alone, and then I've documented the last time you contacted me to leave me alone. You're disseminating lies about me, and that is defamation. The truth is the only metric that saves you from defamation, and I'm telling you, I have no criminal record. I've already downloaded your video. You have 24 hours to retract your statement or face legal action. My legal team has been blind carbon copied on this email. My legal team, Jesus. On Monday, I will sue you. It's that simple. I do not wish to have any contact with you. I do not wish to return correspondence from you. If you continue to harass me publicly, you will end up in federal district court. Last time you contacted me to leave me alone, you are here we go. I will check your social media channels for the retraction. If it is not complete and full, you'll be served a lawsuit next week. I don't care if I win. I care that you have to hire a lawyer. I care that I extend the process for as long as I can to drain you. For the last time, you stupid, retarded fuck. I'm not interested in your relationship with you, and I've continually told you this. I don't care that you're a loser and you have nothing going on with your life. You have no motivation. I don't care. I will be checking your social media channels tomorrow. I hope you think I'm kidding. I hope you think you can do what you're doing and get away with it, you piece of shit. Now leave me the fuck alone. You're damn lucky we have a legal system, and I'm a man of law order, or I would let you know when I was coming, so I could see the look of tear on your face as closed it. You retarded imbecile. The information you're getting off the internet isn't true. Dumb fuck. You'll find out in court if you don't retract what you said about me. By Friday, we will be putting the lawsuit together. I hope you don't listen. You can't fix stupid, and you're a fucking retard. Jose M. De Castro, a.k.a. Chile, from Delete Laws. So there you go. So what happened? So the judge granted the motion for the status hearing, i.e. a judge set a status hearing. That's not the judge that's assigned to the case. This Judge Patty B. Saris set a status hearing for the same day at 4 p.m., gave out the telephone number. In the meantime, Chile filed his request for production and documents and things to the defendants, and good luck. So Chile, who, by the way, just once again for the record, is signed up for the electronic service, didn't show up. So these are the electronic clerk's notes for the proceedings that were held before Judge Patty B. Saris. The emergency status conference was held by phone. Plaintiff pro se did not appear for the status conference by telephone. It's ordered the defense attorney wish shall file further briefs for equitable relief by 10/20/2022 by 12 p.m. What that means, the briefs are basically he's going to lay out the legal framework for why he's entitled to either the default, i.e. the terminating sanctions, Chile loses, done, case gone, and or why he's entitled to some sort of injunctive relief preventing Chile from contacting Kate, or at least harassing Kate, and from harassing Wish. That's what the court is instructing him to do there. So the court will have the legal reasoning before it, so they could grant what he's asking. Now, obviously, just because he provides the court with reasoning doesn't mean the court has to believe his reasoning or go along with his reasoning. And the court does have law clerks that will be doing their own research onto it. So, he may get what he wants. He may get some of what he wants. I suspect that there is a high likelihood of success on the injunctive relief preventing Chile from harassing Wish and or Kate, and I would predict there is a low probability of prevailing on the terminating sanction, the default. Plaintiff shall file a response by Monday, 10/24 by 9 a.m. The hearing is to be held on Monday, 10/24 at noon before Judge Burroughs by video. And then the court sent out an electronic notice of hearing. This hearing will be conducted by video conference. Counsel of record will receive a video conference invite at the email registered NCM/ECF. If you have a technical or compatibility issue, yada yada. Access to the hearing may be made available to the media and public. You must sign up there. For questions regarding access to hearings, you may refer to the court's general orders, yada yada. So, since Chile is signed up to CMECF, so he has received his notice of it. So if he doesn't show up, well, I'm not saying that the court will do anything bad. The court might just continue it again to give him another chance. The courts do tend to give pro per plaintiffs a lot of chances. But the court may also just wish the relief that he's requesting on Peter's behalf. So we'll see. We'll see. So keep your eyes and ears out. I'm going to copy that link address. The link to sign up for the media and public will be in the description of this video, so you don't have to pay to download it on Pacer. And thanks for watching. Have a great day.